Are
we there?
Cool. Thank you. Okay, bye.
Can everyone hear us now? Anyone? Oh, yep.
Yep.
Perfect. Wonderful. All right, a little bit of a false start. We were up and running, and then, of course, the computer did not want to play the game. So I will just pop that back over here. And how did we do that before?
Slideshow, start slideshow.
Start
You go.
file.
So see slideshow across the top.
Top menu bar, Tammy.
No, I can't see that.
I'll show you later.
Oh, here we go. Got it. From beginning. All right.
It's not shared. I don't believe it's shared on the Teams meeting though. It's
Not shared.
It's not linked. So
What do we do? Link?
just share. Oh no.
No.
See the present button? I don't know. See above reverse with questions.
Present in
Oh,
Teams.
yeah.
You might be able to
I see present in Teams.
Start.
Yeah, across the.
because you
Open.
Yes.
Oh, my goodness.
okay, it's all right. So we need to open the PowerPoint, but go into the Teams meeting and then go share from within the Teams meeting and choose, see that button? Yeah, that, click on that. And then you find it, the file.
There we go.
And now you can do it.
Yeah, you got it.
Yeah, now it's showing on this screen in full.
In full,
It's showing in full on this screen.
but not on mine.
Oh, that's okay. You can.
Everyone's right with that if we leave it like that?
Someone just said they can see it.
Perfect.
Yeah.
Wow, I do apologise. I'm so sorry. I think I'd be getting better at this by now. Thank you everyone for coming online in here. Thank you. Very, very pleased to introduce Danny Flickford tonight from CG Law. If you don't know Danny, he's amazing and very knowledgeable, and we're very privileged to have him here. So yeah, I'm sure you'll all make him feel very welcome. And you know, if he asks you questions, please be involved. So yeah, really important. So drink up the wine, ladies, and if you're online, you can drink as much as you like because we won't sink. So yes. But anyway, thank you.
All right. Well, thank you, Tammy and RE Australia and the PHN for inviting me along tonight. It's always, I was just saying to Tammy, I spend most of my days sitting at a desk. Occasionally, as a lawyer, we go to court, which is always a little bit stressful. But otherwise, getting out and about and actually talking to people and meeting people is one of the more fortunate things I get to do, and I probably don't get to do it enough. So thank you for the invitation, PHN as well. And as Tammy indicated, very much looking forward to an interactive session tonight. The reason is twofold. One is this is your chance to ask any legal question you want. So if there's something that's happening and you and you need and you're looking for an answer, if it's to do with workplace law, that's much better. If it's to do with anything else, well, I'll do my best to answer it, but I may not be able to. But the second thing is, the second reason why it's good to have interaction is because it means that the session is a lot more relevant to you and your day-to-day practices. Unlike you, sorry, I only have a small team of lawyers as part of a bigger team that I need to occasionally manage. You guys have, I anticipate, a broad range of personalities across a broad range of health professionals, presumably doctors and other allied health professionals that you're dealing with. And so this is, so your job is in many respects a lot more complicated than mine. Tonight, we're going to be talking about psychosocial hazards. Now, I'll give you a bit of history as to where we've come to and how we've arrived at this particular moment in time. But I remember many years ago when I first heard the term psychosocial hazard, I started to break out in cold sweat because I was thinking, what the hell is this? And how's it going to impact what we do? Is it going to impact me and our firms? How's it going to impact clients and all the rest? And so what I'm going to hopefully help you tonight is get a bit of an understanding of where we've come from, talk about psychosocial hazards, and try and make it as not overwhelming as it possibly can sound. Talk about a couple of case studies. We've got a couple of case studies or European case studies that I want to talk about tonight, and also give you some case examples. So that's what I'm intending on doing. If anyone has anything else, as I said, that you want to ask, this is your opportunity. Make sure you ask questions, and hopefully it's an enjoyable topic to be entertaining with. But we'll try and make it as entertaining as possible, and as informative as possible for you. But hopefully this works.
Yeah. The button's down the
Oh,
bottom.
the button, you've got that
Arrow.
laser on.
Yes.
Oh, you know what? It's all right. I know one.
It's got a red battery flashing. Anyway,
You can manually change
You
it
can-
online.
you can manually change it. Slide 2. Slide 2 is the most important slide. It says that none of this is legal advice, and so whatever you hear tonight, don't rely on, and everything else after that, well, it doesn't matter.
Can you change it? Sharon?
Only on my screen.
All right. Well, that's okay. If everyone flips to,
There we go. There we go.
oh, there we go. So I have to come over here and do that.
No.
Oh, no. You'll be standing there for a while, and I lose track of these. So
Yeah.
It
It's showing up correct on there.
Okay, we want
oh, click that one. Yeah,
Yeah.
sure.
overview. Overview.
Okay.
Someone wants to come in.
I'll let them in.
Thank you.
So, does anyone before I do start? Does anyone either online or in the room have a question about psychosocial hazards? What have you heard about it?
1 second, I'll read them.
No, yeah, that's right. I thank you for the reminder. There is a paper that's hopefully been circulated around. Please don't read that because that's for you to read later when you've gone home and yeah. Well, it's not homework. It's just that hopefully it's a bit of a reference point for you. So after you hear what I talk about tonight, you can go back to it, and some of it might make sense based on the content of that little paper. So. That's the purpose of that. So I'm certainly not going to go through that in any, probably with very little relevance to what I'll probably talk about tonight. But anyway. So yes, before I start, psychosocial hazards. What do people think? What immediately springs to mind?
Another hazard that we have to manage,
Yes. Okay.
or maybe we're already managing it and we don't label it like that.
Yes. Labelling is an important part of this exercise.
I would imagine like the stressful environment that's causing psychological stress to your workers, etc.
Stress is one factor. Stress is probably the outcome, if you like. We're gonna step forward a few paces before we get to the stress point to try and identify hazards. But yes, absolutely.
I think as managers, you've got a responsibility to try to mitigate these kind of risks on your staff, as in bullying and harassment. It's kind of around that, and that's what I think.
Yeah. No. Sorry, but can I just Yeah, the part about you as managers is a really important part of what we're going to be talking about tonight, and I'll explain why later. But there is a level of probably expectation and a level of responsibility that comes along with that expectation that you probably don't anticipate belongs to you, but in reality, in practice, it probably does.
I was just going to add, like, clear understanding of the roles, the expectations around the roles, and the expected performance, so that doesn't add to the stress and the overwhelm.
Yes, I mean, absolutely, and all of that again is part of the process. It's a step along the way. I guess, as I alluded to at the beginning, a bit of a history of how we've got here. So this has been talked about in government circles, this idea of psychosocial hazards since around 2016, 2017. 2018, there was a task force put together in conjunction with WorkSafe Australia to start to identify and review certain parts of the work health and safety legislation to try and identify risks that may exist but haven't yet been labelled or identified. And I guess what's important about that is in Australia, we have WorkSafe Australia, which is a Commonwealth body that sits above everyone in the states, and it makes recommendations to the states about work health and safety laws. Work health and safety laws are actually state-based legislation, which means that what happens is that the states have a look at whatever the recommendations are from that particular government body, and they either adopt or they don't adopt part or all of the legislation. Now, the difficulty with that creates is that what happens in Queensland with work health and safety might be different to what happens in New South Wales, Victoria, South Australia. The territories are different, and Western Australia. So if you did decide to get up, or you've got a practice that goes beyond the border, or you decided to get up and move into state, the expectation is, I guess, everyone has, is that, well, when I go into New South Wales, the work health and safety laws will be the same. And for the majority, they are, but in some circumstances, they're not. And there's a point that I'll raise about this later. But what happened with this program at a Commonwealth level is that there were 39, I think, recommendations made to the states for them to adopt as part of their overhaul of the work health and safety legislation. And 35 of those recommendations were adopted and 4 were ignored because they said they weren't irrelevant or outside the scope of what it is that they wanted to consider. My expectation is no one has an idea or no one has read any of those 35 recommendations. I'm guessing.
No.
No, and I don't intend to go through all of those recommendations tonight. But one of the recommendations was that they wanted that we would adopt a set of work health and safety laws to manage psychosocial hazards. So that's how so that happened then in 2021, that we adopted at least one of we adopted 35 of the 39 recommendations, but one of them included psychosocial hazards. And I've identified, I've written down 4 that I think are important, and we're only going to be dealing with the psychological health issue. But I think it's important that you're aware of the other 4, particularly in your role as managers, because they're relevant to you. One is that when it comes to workplace health and safety, you have an obligation to consult. So consult not just with your individual staff members, but every other third party that might come into your ambit in your role as a practice manager on a day-to-day basis. So there's an obligation to consult with every individual. That includes, obviously, the doctors themselves, patients, suppliers of material. I don't know whether you have conversations with the pharmaceutical companies, everyone that comes into your orbit, and there are issues relating to work health and safety. You've got an obligation to consult with all of those people that come within the ambit of your role as the practice manager. So that was the second one that was adopted. The third one that was adopted was that if you get it wrong and you're prosecuted, they increase the fines. So that happens fairly regularly. You might not be too surprised about. The fourth thing that I thought was pretty significant, and this is a bit of a legacy issue for work health and safety, is they prohibited the capacity to get insurance for breaches of the Work Health and Safety Act, so fines imposed because of a breach of the Work Health and Safety Act. So in Queensland, at least, the Work Health and Safety Act says that an insurance company can't provide you insurance for a breach of the Work Health and Safety Act. That includes the doctors themselves, they can't get insurance, it's unlawful. The practices themselves can't get insurance. Pharmaceutical companies can't get insurance. And what that means is that if you're prosecuted for a breach of the Work Health and Safety Act, and you're fined by the court because you've breached the act, you got to cough up the money. You can't try and get it from an insurance company or have them cover neither the fine nor the expenses associated with that particular issue. So they were 4 of the 35 that were adopted, and I thought they were pretty important. Any questions? Yes.
How does that work with contractors? For example, you own a practice, but your contractors. Work on
The doctors are the contractors?
the doctors are the contractors,
Yes.
and they breach the Work Health and Safety Act. Does that also implicate the practice itself?
So, yes and no. Great lawyers answer that one, isn't it? Yes, it depends. Yes. And this is a good segue, and I don't mind talking about this. I wasn't going to cover it tonight, but it's an important side. No, that's right. It's an important side issue. Work health and safety obligation is what we call a non-delegable duty. What that means is that there's a definition of a person who is a duty holder in the Act. So a duty holder is really any worker that has a responsibility under work health and safety legislation. So employees, workers, which means contractors, and employers. So the PCBU is a person conducting the business or undertaking. If you have an obligation, that obligation is absolute. You have a full responsibility to discharge your obligation to ensure the health and safety, including the psychosocial health and safety of an individual. So to say that is a doctor responsible as a contractor for their work health and safety responsibilities? Short answer, yes. And it's a non-delegable duty which they can't pass on to the practice. Yep. Now, the reason why I also say no is because you have, under the Work Health and Safety Act, those obligations are quasi-criminal responsibilities. So what that means is that if you are prosecuted for a breach of the Work Health and Safety Act, it's a quasi-criminal prosecution. So you get a notice, a prosecution notice, a complaint and summons from the court, served on you potentially by a police officer, to say, come along to the court and answer this charge. The charge is you breached the Work Health and Safety Act. You turn up then, if you can be named personally, or the company can be named as also as a duty holder. You turn up and you either plead guilty or not guilty to the charge. So if the doctor was accused of breaching the act by the Department of Work Health and Safety and or the practice, 2 separate charges, you're both turning up at different times to answer the charge, guilty or not guilty, in relation to a breach of the act. If that breach of the Act, though, resulted in a personal injury to a person, separate issue. So that's dealt with under what we call the Civil Liability Act. And that is where you get into this murky territory of contributory negligence. So let's say someone injures themselves at work and the practice says, well, it was the doctor's fault. The doctor says it was the practice's fault. And all of a sudden there's tension. Under the Work Health and Safety Act, doesn't matter. You're both prosecuted, you both turn up if there's an injury, and you're prosecuted and you answer the charge. With the personal injury, it's civil law, so it's not the quasi-criminal prosecution. That's where we start to talk about, okay, you were, as the practice, maybe 90% responsible, so you wear 90% of the damages associated with that claim. That's and if the doctor contributed 10%, the court decided their contribution was 10% of the duty that they owed, and they were negligent and it resulted in damages, then they would be responsible for the 10%. And that's where your insurance kicks in. So you will generally have insurance to cover those types of claims. What we're talking about tonight with the work health and safety legislation, though, is, as I said, there's no insurance and it's an absolute responsibility. It's a non-delegable obligation that you owe as a person who has a responsibility under the Work Health and Safety Act. And sorry, I didn't catch your name, Kerry. So when Kerry was said before, us as practice managers, well, unfortunately, and in a position of responsibility, you've got a duty under the Act to ensure work health and safety obligations are met. And so there is I suggest probably a minor risk, but there is always a risk that as a duty holder, you fail to discharge that duty, you could be prosecuted, for which there's no insurance. You can't ask someone else to pay the fine. You're stuck with the charge, the fine, and perhaps the conviction of breaching the Act. Yeah. Any questions? Sorry. Hopefully that answers your question. Yeah.
I need more wine.
If anyone online has a question, where can they ask it? Oh, so Sharon, you'll see. Yeah,
There's no questions at the moment.
okay, good. So, and that's a really important part of understanding what we're talking about tonight. So that's why I don't mind talking about it, because understanding that it's that level of responsibility is important, because you've got then obligations to discharge your obligations under the Work Health and Safety Act. Okay. So we've the next part I want to go to, and forget about my slides. I can't see them. The idea of what is a psychosocial hazard, and we were talking about stress before. That is probably the result of a psychosocial hazard. There's been some definitions that are thrown around, and one definition that I thought, well, it's from the New South Wales public health sector, and they talked about it in context of a disability, not just a psychosocial injury, but as a disability. And they say that it arises when, and I'm not saying this is the definition that is necessarily right, but it's one definition. Arises when someone with a mental health condition interacts with a social environment that presents barriers to their equality with others. So for me, that means that if a person, means that, let me rephrase that. So a psycho, and this is the difficulty with it, understanding what a psychosocial hazard is, because what we're talking about are social interactions in a workplace that has a workplace that is considering the physical, the emotional, and the psychological welfare of the individual, and any hazard that might impact in the workplace on any of those issues or items has the potential to be a psychosocial hazard. So this is where it gets to me. When I first read about this, I was thinking it's pretty overwhelming, because if you think about any social interaction or any interaction in the workplace, when you consider it in the context of your physical environment, your social environment, your emotional environment, all of those things, that every moment of the day potentially is a hazard or a risk that might need to be managed. The difficulty, I think, or one of the difficulties, is trying to work out for you as with some level of responsibility of managing a whole range of environments and circumstances, is identifying how you're going to pick up the one issue that may cause a problem that you then need to manage. So I think, for example, if an example that might be in my workplace is that if I went to one of the junior solicitors and I said, tonight you're going to go present to really nice people about this particular topic, and that person I know that person has never done it before, may not have the skills to do it, may not have the emotional capacity to do it. Am I putting them at risk from a psychosocial hazard? And the short answer to that is possibly. So identifying, understanding what a psychosocial hazard is becomes really important.
What if it's part of their role?
Yeah.
Mm.
So, I will come to a slide in a second, but my answer to that is it's always going to be part of their role. So the hazard that you're identifying is well, when I say always, I probably 90% of the time is going to be because of the role that they're undertaking. Maybe they're not trained well enough. Maybe they don't have the skills. Maybe there's no clear guidance on what their expectations are. All of those things are part of your role, but if they're not properly explained or properly understood, they create psychosocial hazards. So I guess some feedback from you, can you think of a moment or think of a role where there is that potential for?
What about if they know what they're to do,
Yes.
but they then refuse to do it?
Well, that's different. And the only reason
They're not refusing to do it. They're just, they're deciding whether they want to or not.
yes.
I have a receptionist similar to that. I think that she was anxious at the interview. She told me she was anxious. She said, I get the job, I learn it well, I can do it. And now she's in the role.
Yes.
She's anxious, she's finding it overwhelming, and I'm putting all the supports in place.
Yes.
But the role may just not be for her. The role is what it is. So for her to interact with people and keep her head about, and the phone's ringing and the computer's going, and now I'm in a position where if I stop giving her shifts or I can worsen her anxiety somehow.
Yes.
But so the role is a psychological hazard for her.
Because it's not, they don't necessarily have the skills in order to manage and cope. And that's, I suspect probably a common scenario across most of your practices. We can break that down a little bit and work out how we manage it in a little bit.
Yeah.
What I do want to focus on though is still understanding this idea of what is a psychosocial hazard. In your papers, there's a reference to sections 55A capital A and 55 capital B of the regulation, the work health and safety regulations, and it actually gives us a definition, a statutory definition of a hazard. So it identifies a hazard as the design or management of work. So yeah, the design or management of work, a work environment, plant at a workplace. So if plant, and I'll come back to this particularly in the world of AI, workplace interactions or behaviours that may cause psychological harm, and they may cause psychological harm. So that "and" is important. So you can see how broad the definition is from a statutory perspective, and what you've got to try and try to understand that, and then try to understand how you manage that on a day-to-day basis becomes very much a challenge. And we'll come to that. We'll try and give you some tips and tricks.
So I know the other end,
Yes.
having an employer.
Not you tell me not to.
Way before that, but yeah, like they're always right. They put pressure on you. Whether Kylie remembers whether I came to you that time and I said, I am not okay.
Yeah.
It was just things got to me. Usually I am fine, but that time it was, not good. And that
Yeah.
was from someone higher up.
Yes.
Yeah.
So I think how we've got to this moment in time is there's been a history of trying to deal with that in terms of the definitions of bullying and harassment and other labels that you might try and attach to that. And if you don't hit those labels, well then there's no consequence, if you like. So trying to create this environment where people are, I guess, respectful of the role and respectful of other people's skills and abilities, then we're trying to remove all of those psychological risks associated with turning up to work on a Monday to Friday 9 to 5 basis. And it's hard. And obviously the law needs to recognise that every role will have an element of stress. And this might be jumping ahead a little bit. I don't want you to think that every element of anxiety, every element of stress that a person suffers is necessarily a hazard or risk that you need to manage, and or that it's compensable in some way, shape or form, because the law recognises that there is stress and anxiety associated with the role. I mean, if I tried to say to one of my solicitors, go off to court and didn't expect them to be stressed or anxious, no one would be doing it. So there has to be some recognition that roles are going to be stressful, anxious. But what the legislation is trying to do is get you to be proactive in managing that. So to understand that, okay, that's going to be a stressful moment. We know it's stressful because of a history because we might have done these things in the past. But what can we do proactively to try and manage that stress or anxiety? What tools can we give the person? What physical environment can we change in order to try and make that situation less stressful for that person? And that's the expectation.
It's hard when someone's got
Well, yeah, and absolutely, and there's ways that when we look at the case studies, there's ways and means that organisations can deal with that and have dealt with successfully.
Mm-hmm.
Maybe it's easier in a larger organisation than organisations where there's not that many people and you're having very regular contact as opposed to occasional contact. But at least there might be some learnings from that when we get to it.
Sorry,
Yes.
are you still swapping the slides for the people online?
No,
I just let them know that they can flip through them by
Yes.
themselves.
I will identify.
But they're not going to know where you're up to.
Well, to be honest, the slides have nothing to do with what I'm talking about. In fact, I've forgotten my notes on yeah.
Very good.
Yeah, terrible. Anyway, back to my notes. I'm trying mix them centrally.
I was online once, so I know how it feels to not be able to know where we're up.
Yes, yes. So please don't think that I'm following a coordinated or logical path along the slides, but I will come back to a couple of slides that I think are important.
Don't want to cause any cycle.
So, coming back to the legislation, because this is an important element of you having a set of skills and tools to manage these types of situations. There is built into the legislation defences to breaches of, as you might imagine, to a breach of a work health and safety obligation. One of the identified defences that will 9 times out of 10 be a complete defence to a prosecution, if you like, is compliance with any relevant code of practice that applies to a particular set of circumstances or issue in a workplace. Hands up if you've actually seen a code of practice. Yep. Yep. So these are important. And if there's one thing that I can that you take away from tonight, it's when you go to work tomorrow morning, go to the Queensland Department of Work Health and Safety, go to the codes of practice and read the code of practice. Maybe not, it might take you to read it, but read the code of practice that deals with managing and preventing psychosocial hazards. There's a code of practice. Now, the reason that's important is because, and I keep coming back to a legal perspective in this moment in time, is because if you're prosecuted or if you're being investigated for a breach of the Work Health and Safety Act, one of the first things the inspectors at the Department of Work Health and Safety will ask you is, can you give me your documentation as it relates to this particular issue? What they will be hoping to see is that you turn up with the code of practice and you turn up with all of the documents and all of the information that is recommended in that code of practice to say, this is what we have in place to manage this particular issue at work. And because those codes of practice, there's a particularly, it's not on the screen, but in the forward to the managing psychosocial hazard code of practice, it says, in most cases, following an approved code of practice would achieve compliance with the health and safety duties in the Act in relation to the subject matter of the code. So it tells you in the introduction paragraphs to the code of practice that compliance with this code will show you that you're complying with the Act. And the safest and most wholesome piece of advice that I can give you tonight is to go away and have a look at that code of practice. Make sure you download it, read it, because it's got a heap of practical guidance in it, and and start to work your way through that code of practice and implementing whatever you think is appropriate for your workplace as it relates to that code of practice. Yep.
I think I wrote the psychological safety action plan from the code of practice.
There you go. Yeah. So it has from memory. I've looked at the forward today, but I haven't read the entire thing for a while. But from memory, it actually has a list at the back of it of items that are identified risks when it comes to psychosocial hazards. And it's a useful tool to go through to that list and say, okay, well, that might be relevant. So let's create a process for managing that particular risk. That one might be important, and so on and so forth. What I don't want you to do is when you download it, be overwhelmed by the size and content of it, because workplace health and safety is a journey. It's not a destination. It's something that you will always have as part of your role as in any managerial responsibility, in any role that has a managerial responsibility. Work health and safety is always going to be a part of that. And it's about doing things on a ticking boxes off as you go along that journey to try and achieve whatever the standard of compliance is that you're trying to achieve. No one's ever going to prevent every incident or injury that happens in the workplace. We hear day in, day out of people either losing a limb or, you might have doctors that deal with these emergency situations. So you see them physically, firsthand, or deaths in the workplace or whatever the tragedy might be. Unfortunately, that's just the nature of every workplace. But trying to do the best that you can, making every reasonable attempt with the resources that you have available to manage these work health and safety risks, that's the expectation. And the easiest way for you guys to do that, in particular in relation to this particular issue, is to get that code of practice and work through it and follow the hazard identification and risk management processes that are set out in that code of practice. All right. Any questions from that? Make sense? Everyone online's okay with that?
Yes.
Okay. All right. So, if we go to, I will go to a slide.
You like them?
So,
It's hard on the screen.
yeah. As a duty.
Don't proceed somewhere in this.
So, let's see. Okay. So, examples of psychosocial hazards. This helps, I guess, put in some context some already identified psychosocial hazards that might exist in a workplace. Remember, if you come back to your definition at section 55A of the regulations, it talks about the design or management of work, a work environment, plant at the workplace, or workplace interactions or behaviours. So these are some from the code that are examples of psychosocial hazards. Now, sorry, I've forgotten your name. Valma. So Valma, when you were talking before about workers that may be overwhelmed or stressed by the tasks that they're doing, if you look at this, maybe, these are the hazards that you need to tick off to see whether there's anything in here that might be the cause of that stress and anxiety, because that might be the hazard that you then need to try and manage. So, for example, low role clarity, classic example of what creates stress and anxiety for a lot of people in workplaces. What's my role here? What's my function? What am I meant to be doing? Yep. And obviously then through to the more serious things like bullying, harassment, and sexual harassment. Yep. So I was going to suggest a task here where you write down 3 to 5 hazards that you might think of right now. having regard to these examples that might exist in your workplace, and the hope, if there are some, great. If there aren't any, great. But the idea is that it might be something that you take away with you, and then tomorrow you go, okay, this might be the first step in the path to managing psychosocial hazards in the workplace. So does anyone want to spend a couple of minutes just thinking about this, or not read them? So it says,
What's that one?
high and or low job demands. I've always think low job demands
Yeah,
is.
I don't think they
I
did
don't
that.
know.
Definitely not.
It might be the opposite of obviously having too much to do is not enough.
Like if I'm being a senior receptionist and being put just straight on reception and expecting to run that reception after doing all the work that I do, I would find that very
Degrading.
no, right, because I get my brain is busy and I like to be busy. And
Yeah.
being put from a high task role to a low task role would just be absolute murder for my brain.
Yeah. So yeah, absolutely. And it might be only part of your role. It might be your whole role. You know, some people might sit there day in, day out thinking, how do I justify my role here? How do I justify the wage that I'm earning when I don't really have anything to do? I'm too afraid to put my hand up. But that low job demand might actually be a cause of stress or anxiety, for which then creates a psychosocial hazard.
It's very difficult to have it balanced the whole time.
Yes, it is. If you find that job, can you let me know?
Yeah.
Actually, it reminds me there was an article I read a few years ago about a guy in Italy, as part of the health system. He worked for one of the Italian hospitals, and he didn't turn up for 15 years. He was being paid week in, week out for work. That might be that job where you find the perfect balance between I'm getting paid to not do anything. Anyway, he got caught. I suspect either had to pay it all back or whatever. But who knows in Italy? But he was probably celebrated in some way, shape, or form. But that's a little side issue. The other one here that I think is, and this is going to be something that I think into the future more and more difficult, is this issue of organisational change management, particularly as it relates to work practices that are impacted by artificial intelligence. So the more automated our worlds become, it might result in ongoing organisational change, the taking away of responsibilities, the adding in of responsibilities, depending on the impact it has on your work. That poor organisational change management may be a trigger for a psychosocial hazard.
And it is fully,
Yeah, I was going to say.
it's fully helping us.
To reach that goal?
Yeah.
We're all well on the way for that one.
We're going to come under trauma. Something and then they change it back the day before it happens. Like,
Yes.
it really is very hard.
Before the 1st of the 7th.
Yeah.
So-
I spent 2 weeks getting ready for something that was going to come on the 1st, and then
Yeah,
on the
there's a lot of
29th it stopped.
Yeah, right. Okay,
And
perfect.
so your staff like going, what is
Yeah.
going on?
So, I mean, that's an external factor that impacts on the system, but if you've not been managing that change in a productive and appropriate way, then and that change management leads to stress and anxiety, then there's a psychosocial risk associated with that.
I think it's a little bit of perception though too, like we can work as hard as possible to have that change management and make it as positive and encouraging.
Yep.
And then, but the perception is like it's changed on the 29th,
And then, but from everyone else in the team, they're like, oh, you don't know what you're doing. You had us doing all this stuff. And then all of a sudden it's like, we're the bad guys.
Yeah.
They're like, you don't know what you're doing.
Yeah,
Yeah, we had meetings with doctors and, you know, like to be able to bring this in.
yeah. And I guess it's, you know, that it's difficult to understand from right now what that must have felt like, but it seems, you know, obviously communication is an obvious and issue that needs to be considered.
Yeah,
In that
it's
moment in
the,
time.
I guess, yeah, it's the external stakeholders
Yeah.
sometimes that being in health you don't have a lot of control over.
Yes.
And you are, yeah, you're hamster on the wheel sometimes.
So the other thing about organisational change, particularly with technology, that is a consideration is the age of a person.
Yes.
So you might have a young person who's fully understanding of every technological consideration in relation to an item or a process, through to people who don't use computers or haven't hardly used a computer, yet all of a sudden this change is happening. And it's again, when you do your risk assessment, so the idea is, if you think about if Medicare are bringing in a change, it's about getting an understanding of that and working out a map or a process as to how we're going to do that or implement that change. And as part of that process, you're doing a risk management assessment. You're probably doing it without realising that you're doing it, but you're doing it, no doubt, because you're planning for outcomes. As part of that, what this wants you to think about is the psychological hazards associated with the implementation of this, and what does that mean for the workforce that you have? Is it a linguistic issue, insofar that the people you deal that some of your team members' English isn't their first language, and so an understanding of what terms might have different meanings in different environments or cultures? Is it an age thing if it's based around technology? Is there training and skills required to enable people to be able to manage the change associated with, you know, whatever it is that's being implemented? So that code of practice that talks about your circle of risk management will have these steps in broad language, but you've got to take that information or take that idea and apply it to your particular scenario. So when it talks about hazard identification, okay, what are the hazards associated with this in an organisational change management situation? Yep. The next slide really just is to reinforce it, because it's what lawyers like to do. They like to. Our best form of marketing is to scare people when you're doing something. I'm joking. So the effective psychosocial hazards, you can't probably read that, but it goes from the things like anxiety through to self-harm and suicide as psychological responses to workplace issues. Then physical responses like cardiovascular disorders and other stress-related injuries. So that's they're the extreme situations that are possible consequences that you need to be managing as you're going through this process. So I can think of one issue in our workplace. When courts started to move to e-courts. So what used to happen as an article clerk, when I was an article clerk in Brisbane, you'd have to file a claim by 4 o'clock on a particular day. So the partner would come in at 3:50. You're at Riverside Centre and you had to make your way to George Street and said, this needs to be filed by 4 and don't come back if it's not filed. So you'd grab it, you'd in your suit in the middle of Brisbane in midsummer, race to the other end of town, get to the registry, hopefully before 4, they were annoyed as all hell because you were going to keep them beyond 4 o'clock and they look at it and they go, oh, you've spelled the judge's name wrong. I'm not going to accept it, or something like that. You know, then you'd pick it up and you'd race it back. And so that was the physical environment and causes of stress. So, and we used to, and you can't do that these days, but back in the late 90s, you'd also at Christmas time turn up with cases of rum and whiskey and hope that they'd remember your name and your firm that you were. So next time you turned up at 4 o'clock, they'd overlook it and just say, yeah, come on, yeah, exactly. This isn't recorded. You can't give anything to a court registry business. But the times have changed. But and you used to, when you go to court, you might have 10, 15, 20,000 documents or pages of documents, not uncommon. And so you would turn up with suitcases, dragging suitcases into court.
So we all street and I'd see them go.
Yeah. Put trolleys along with big. So then they went to e-courts and everything's filed now. And so there were a lot of practitioners that weren't used to reading documents on, even judges themselves, weren't used to reading documents on a computer system, or the fact that you could file something via email or logic, going into a court system and uploading it. And so that significant change is caused a lot of stress and anxiety, particularly for older practitioners that weren't used to using computers in that level of efficiency and that type of way. So I'm sure there are examples that you guys can think of in your day-to-day where you've moved from, maybe, even just the notes that the doctor keeps where you couldn't read the handwriting and someone had to input it into a system, through to now, presumably there are codes that doctors can tick that have, meaningful explanations based on the code. The whole billing system in the Medicare system, for example, with codes and what have you. There would have been a fair bit of stress and anxiety for practitioners to move from that into from the hand-based to what we have today. So they're examples. Now, probably during that period of time, the idea of a psychosocial hazard didn't exist. Now, if that was to happen, there would have to be this sort of organisational change management consideration of, okay, this is what we need to implement. What's it going to be? What's it mean for all of these practitioners?
I guess we've got a lot of new AI products that we use.
Yes.
And especially for our receptionists, if we're, putting on a new software program that automatically does our scanning for us, so it reads the emails, it automatically does those kind of things. I think sometimes me personally, I might think, oh, that's fantastic. I really want to get that on board, and I'll tell our receptionist, oh, we're going to be doing this. We'll be doing this. But then not thinking how great it is, but then maybe not delving into it with them and making sure that they actually understand that this is going to be good for them and this will help them without taking away their job or without that feeling.
They have that feeling they're going to be.
Yeah, well, what am I going to do now? I'm not going to be, so there's that kind of thing. And, it's evolving so quickly and there's so many things, and we're always trying to work smarter, not harder. But I guess it's just that flow on, we all deal with change management every day.
Yes.
But I guess it's looking at it probably a little bit more closely and
and
maybe
it might be
changing and talking more, communicating.
Well, and it might be. Do we want to? I mean, it's 5:06. Do people need a break, or are you happy for me to just keep pushing through?
Do you need a break?
No, I'm okay. And so I might come to the case studies in a moment, because that's a really good point. The one thing I would say though is that it's important for you guys as the practice managers, I suspect, to recognise phrases that people start to use. So you know, if one day a person might say, I'm feeling a bit overwhelmed. Next day, you never hear it again. If that conversation starts to move from I'm feeling overwhelmed to days off to, you know, all other sorts of physical or emotional responses to what would ordinarily have been a simple request, that might be a situation where you've got someone who's moved from being able to cope to not being able to cope, and at some part along that process, you need to be able to identify and intervene and have a process built into your work practices to identify and intervene before it gets to that person taking, you know, significant time off and all the rest. So, you know, yes, that's right, as you're saying, explaining to people why,
Yeah.
but also then listening to the comments and the reactions as they implement and get about doing what it is that you've asked them to do. Coming back to your point before about if they refuse to do it, well, that's just a behavioural issue that needs to be managed. That becomes a performance issue rather than
I wanted to expand on Kylie's one about them refusing to do it.
Right.
How about if you've given them the workflows, you've given them the training, you've offered them EAP, you've done absolutely everything you can to help them, and they still say, I'm overwhelmed, I don't know what I'm doing. What then? You've done everything, absolutely every single support you can do,
Yeah.
and they're still telling you, I'm not supported, I don't know what I'm doing.
Yeah, there's I guess there's depends how it presents, because if the person presents as being absent from work, it becomes managing an ever-engine employee issue. If it is that the person's just obstinate, recalcitrant, not wanting to participate, then it's okay to say, listen, what more can we give you? Because we've given you all of these things. So the expectation is from here that you're going to be doing A, B, C, and D. And one way that is a really useful tool is a performance improvement plan, where you say, where you identify, okay, these are the expectations, this is the skills and training that you need to recognise that we've given you. So the expectation is that you can now do this job. If the person can't, despite them being placed on this performance improvement plan where they know at the end of it that if they don't improve, they may lose their job, then that's a well-trodden path to managing a performance issue in that sort of circumstance. You can't, the court won't expect you to continue to do things that are beyond reasonable. I mean, if they're asking for something that's legitimate, genuine, then, you know, the expectation is that you help them. But if it's beyond that, you're at a point where the person is either incapable or refusing to do, despite their being capable, then that's a performance and management. That's a conduct and performance issue to manage. Yep. Any questions online there? Karen? No.
It's really hard sometimes because it's very hard to find good receptionists.
Yes.
And so a lot of the time we take people who haven't got healthcare experience and haven't got anything, and we train them.
Yes.
So it's a new computer system, it's a new language, it's a new, like everything's new.
Yes.
And so we provide all the training
Yes.
to do that. But it is quite a busy job.
Yes.
Like it's not an easy job. And so the overwhelm is kind of part of the parcel. So like we do lots of checking in and lots of how you going, is there anything we can be doing differently and better? Is there and to kind of be doing notes, like it's just a lot.
It is.
On us.
Yeah.
And experience goes a long way.
Yeah.
Because you understand the nature of the job, the expectations, and the likely stress points. So as a person's training, yes, there's going to be stress and anxiety. I guess it's trying to assist them up to the point that you can, And if it gets to a point where no, it's just not working out, well, that's where a decision needs to be made. And I guess that's why there are protections built into the Fair Work Act around dismissing someone, to the extent that if you've got 15 or more employees, you've got a 6-month window in which that you can assess a person's performance. And if they're not adequately performing in that 6 months, you can terminate their employment, and their capacity, they won't have the jurisdiction, or the commission won't have jurisdiction to hear that claim for unfair dismissal. If it's fewer than 15, you've got a 12-month window. So that window is designed for you to assess and decide whether the person's going to make it or not.
Can I ask something? When you're counting your 15, if you've got, like I've got a couple of nurses that do 1 day a week each.
It's a head count.
Head
It's a head
count,
count.
yeah.
Yep. So it doesn't matter whether it's
Yeah.
it's casual, part-time, full-time.
Yeah.
It's just a head count.
Yeah.
Yeah. So
Would
Uh,
include your contractors.
No, I'm talking just admin and
No, but it wouldn't include
generally, no, it
Contract.
doesn't include contract.
registrars or employees.
the registrars or employees, but
Yeah.
it's them.
Yeah.
So yeah,
Mm.
it's what is the employing entity and who are the employees of that entity.
Is it
6
is
months.
it per company? Is it per
So we
company
were
or
always on
per
the 15,
site?
but we're
If you're related bodies corporate or associated entities, by definition under the Corporations Act, it's going to be everyone. So effectively what that means is that if you've got
Yeah.
if you've got 3 directors, for example, and you've got a Wilsonton and a East Toowoomba and a Harlexton branch, but they're registered, they're different companies, but with the same directors and shareholders, it's going to be everyone. Yep.
Going to do it till for 6 months.
So yes,
Yeah.
so yeah, and you know that's the difficulty, particularly in regional and rural areas, is that you put in all that effort,
Yeah.
and then all of a sudden they're not working out, so you've got to go back to the start again, and that's a difficult process and a hard process.
So for those of you who are AAPM members, I called the HR and they said that this lady with anxiety will have a claim under the unfair dismissal kind of pathway. But she's not been there more than 2 months, and I can see it's not.
She's still in probation, isn't she?
So that, yeah,
So unfair dismissal, no,
there's unfair dismissal.
but there's also a claim
Yes.
called general protection.
Yes, that's the one,
So, but there's got to be a right that's been exercised.
right.
So yeah, this
Yeah, yeah,
is
okay.
this is a whole nother topic.
Yeah, that's the one, they said unfair dismissal.
Yeah, so
General protection.
So very quickly, what general protections application is that there's a set of rights that an employee is protected from exercising that are protected rights. Not everything an employee does is a protected right. A protected right is, for example, I've got the right to make a work comp claim. I've got the right to take annual leave. I've got the right to a minimum rate of pay, and I've got the right to ask about that minimum rate of pay. Examples of protected rights. If someone comes to you and says, I'm on work cover, and you say, well, I'm sacking you, then there's a risk because there's a link between the exercise of that workplace right and the adverse action that is the decision to dismiss them. So where people get confused though is that there's 2 general rights: the right to make a complaint or inquiry in relation to your employment. And people think that every complaint or inquiry in relation to your employment is the exercise of a workplace right. So an employee has the right to make a complaint or inquiry in relation to their employment. And if they suffer an adverse consequence, like they lose their job, they're demoted, they suffer a pay cut, whatever, if that happens because they exercise that workplace right, you're in breach of the general protection provisions of the Act. But those complaints or inquiries, the case law says that they need to be underpinned by something. So it's not do I have to wear black shoes today? I really like wearing my sneakers. And that's not a complaint. That may not necessarily be a complaint or inquiry. That if you suffer, if you get, suffer a consequence because you ask it every day for a week, that may not be, that might not be a breach of the Act. So there needs to be some underpinning. That the complaint or inquiry needs to be underpinned by something like a right built into a contract of employment or a right built into.
So anxiety is not necessary.
So with anxiety, what someone might say is, well, I told them I was anxious and they sacked me, and that's discriminatory. So there's a obviously protected in amongst all of that is that you don't engage in discriminatory conduct.
Yeah.
Now, just because someone says that they're anxious isn't necessarily an impairment for which then you can be discriminated against. There's got to be the level of anxiety has to be substantial, or enough to be an impairment by definition.
Yeah.
Okay. So case studies. So these are there's two case studies that I found. Unfortunately, in one respect, they're European companies. Different rules by definition, but the concepts are all the same. The concepts are very similar around managing psychosocial risks. So the first one is and oddly enough, I could only find them in relation to European companies. I couldn't find any Australian ones. Not that I looked. Not that I spent 3 hours looking for them, but these were the easiest ones to find, and I thought they were interesting. The first one is this biopharmaceutical company is based in Austria, and they have effectively a two-pronged system when it comes to managing psychosocial hazards or risks. Step one is that every few years they'll do a company-wide audit or assessment on psychosocial risks. So they'll look at the company as a whole, and they'll do an assessment as to where the risks are based on the work functions and workflows that are in place at that particular moment in time. They'll do their assessment and they'll work out and try and manage whatever psychosocial hazards and risks that they identify. The second thing that they did is create a system of what I would call real-time reporting, and I thought this is a really unique thing for them to do. I mean, when I talk about what they're doing, I recognise that we're talking about a large company with large resources that they have the capacity to do these things, but there might be something in here that you can take away that might be useful in your day-to-day in your practices. So this real-time reporting effectively was that they get a work team, and a work team was able to report to a work health and safety officer real-time about any psychosocial issues or risks that they were confronted with as they were doing their role, as they were doing their tasks. So if I'm working in sales in a pharmaceutical company, and I'm going from calling a prospective client through to finalising the sale, that whole process, at any moment in time, I can send an email off, confidential, goes to one person, and that person then takes responsibility for managing and working through that risk or anxiety or risk or hazard to try and overcome that particular psychosocial hazard. They had the benefit of a team that would respond. So they had and this is the level of complexity or resources that people go to. Sharon's got the right idea, trying to get some. I know, Sharon, it's getting hard. So they would have a work health and safety person. They would have an internal manager, and they'd also have an external occupational psychologist or psychiatrist assist in the management of that particular issue. So they had teams where you were doing your job, and that if that your department was the focus, that person would respond in real time with a view then that person that issue would be dealt with and managed. So if it was a workflow or work function issue, they'd sit down and say, right, what do we need to change in this work procedure to overcome that particular issue in terms of stress and anxiety causes? If it was a management issue, and I think someone raised before senior manager to reporting up, if it was a management issue, they would then come in and talk about that, not in the context of it being a performance or disciplinary issue, but in the context of saying, okay, this is identified as a stress issue. What's causing it, and how do we deal with it collectively to try and manage that particular issue? So they had these two systems operating across the business at the same time. This started in 2023. By 2025, they had no one reporting psychosocial hazards or injuries or risks across their businesses or departments that have been reviewed. So they obviously had a system that was built on trust, and it was built on a system where there was an expectation of trying to fix whatever the issue was. Now, as I said, I recognise this is a well-resourced company with big funds that can throw a heap of resources at a particular issue. And you won't have presumably won't have the same level of resources available to you in managing whatever issues you have. But maybe that idea of real-time reporting and real-time reaction, if it goes to an identified person on a particular day, it might be moments in time in a week or whatever. Maybe there's something in that process or that system that you're able to take away and implement in your own special way, in your own practices. So that's number one. The second case study, again, a large multinational company, was a bank in Spain. They had a similar system where they had because they had numerous branches. They had a set of resources that they would go around and spend, a week or 2 weeks or however long at a time at a particular branch, looking at the workflows, speaking to staff, then doing whatever they needed to do collaboratively in order to try and overcome those psychosocial risks and hazards. So if you've got different locations, that idea of actually going in and spending a week there and listening and learning and watching and trying to understand, as well as do all of your other stuff that you've got to do on a day-to-day basis. Maybe there's something in that enables, that you can get some extra resources or get some free time somehow in order to go and sit with people and observe and develop processes and systems designed to overcome those hazards and risks. So they're two examples where there's been a very successful implementation of the system. The other thing that the bank did, which I thought was unique, is that I don't know whether people have EAP programs. Yep. So they're obviously a confidential EAP system, but they allowed their EAP system to go 24/7. So at any moment in time when a person's feeling stressed or anxious, that person had the capacity to ring up and get immediate assistance. Now, again, that's because they've got big resources and they're able to do that. but it shows you the seriousness with which people are now taking this particular issue and trying to manage it because they see the benefits of it, lower absenteeism, higher productivity, less time spent in HR having to deal with issues, all of those KPIs that would make work life presumably a whole lot better. Any questions coming from that? So I want you all to go tomorrow to the directors of your businesses and say, hey, did you hear what these guys did?
How long after incident or like, so someone, how long can they come back afterwards? Like, what's the timeline? How, like, is there 7 years or 2 years or 6 months?
Have you been reading my notes?
No. I kind of have had people who
Had
didn't,
this experience, haven't you?
who have trained up and it just wasn't for them. And
Yes,
they kind of called it a day.
yes.
But can they come back in 5 years and say, I wasn't well supported and I've now got a psychological injury from working for you for 6 months?
Well, it's an interesting question, and there's a
Sorry, we're just thinking.
Triggered.
There's a, triggered.
there's well.
I think a business coming your way, Nanny.
There's quite a well, now quite a famous decision in the world of employment law, which isn't very big, called Alicia and Vision Australia. Now, this is interesting, partly because of this exact scenario. So Mr. Alicia worked for Vision Australia, started there in 2006. Somewhere in 2014, 2015, he was working off-site and staying at a hotel overnight. Vision Australia got a complaint from one of the people that work on reception that he was unnecessarily aggressive. When he checked out, he threw his keys at them. He was rude and ultimately behaved poorly. Do one on left, Delphina.
Oh, sorry.
Delphina's gone
Must
some
have
wine.
dropped
Some wine. So in 2015, they went through the process of allegations, response, decision to terminate his employment, brought an unfair dismissal claim, and that was resolved, settled the unfair dismissal claim. So they thought, Vision Australia thought the matter was done and dusted. Nothing more that we'll hear. They paid, I think it was reported, $28,000 to Mr. Alicia to effectively go away. After Mr. Alicia lost his job, he suffered significant psychological stress and anxiety, and so much so that he was diagnosed, I think, as not being able to work, and all of the negative consequences physically, emotionally that come along with that. In August of 2020, some 5 years later, Mr. Alicia brought a claim in the Victorian Supreme Court to argue that he was entitled to compensation on two grounds. One is that Vision Australia had a process or a policy built into their systems that they were contractually obliged to comply with, and they didn't, and that failure to comply with that process and make the decision that they did should resound in compensation payable to Mr. Alicia. The second part of the claim was the personal injury claim, which is they also had a duty of care in the performance of their roles to terminate his employment, and they breached that duty, claiming tort, claiming negligence, and he ought to be entitled to compensation. First judge awarded him $1.4 million. So
After 5 years.
after 5 years.
I'm not going to sleep well tonight.
Was that partially though because the unfair dismissal claim had been held up?
So part of what's interesting about the decision is that and there might be some lawyers calling their insurers in this. They signed a deed that said we resolve all claims between you and us in relation to your employment, the termination, your contract, standard wording. The federal court or the Supreme Court in Victoria read though very narrowly in that there was one word missing. So it went the contract, the employment and the termination. If it had have said contract, employment and or the termination, then that deed probably would have barred that breach of contract process as part of the claim. But because it said and, they require it needed all three in existence for that deed to actually work. So that was one word that messed that up. Anyway, that's actually not even the interesting part of the case.
None of mine were unfair dismissal. I'm good.
Yeah. Well, if you've signed a deed, you might want to go back and have a read. He was awarded 1.4. Vision Australia appealed that, and the Victorian State Victorian Appeal Court overturned the original decision and said, no, you're not entitled to compensation. So Mr. Elisha appealed to the High Court. The High Court reinstated the first judges and said the Court of Appeal got it wrong. The first judge actually got it right, and he got his $1.4 million. But and this is, it gets a little bit technical, but back in and this relates to unfair dismissal, and because you asked the question, I'll keep answering it. So back in 1909, there was a famous House of Lords decision called Addison Gramophone. That case has been cited continuously to say that you can't get compensation for the manner of the dismissal for hurt feelings. So because it recognises that every dismissal that's going to occur will suffer. Someone will have hurt feelings, stress and anxiety because of the fact that they lost their job. So the manner of the dismissal doesn't or cannot trigger compensation, and that's been it since 1909. In so the Fair Work Act came in 2009. It would have been the changes that the Liberal government brought in probably around 2016, because the Labor government wouldn't have done this. But that's not a sledge for the Labor. It's
Just their policy.
My staff, I tell them that they have to vote the opposition in at a federal level every year, because they come in and they just can't handle but change the legislation. So that just creates more work for us. So, this isn't recorded either. That's a joke. But I say that because the one thing that I think still separates the left and right side of politics is industrial relations. The Labor government is still all about collective bargaining and workers' rights. The Liberal government is all about a free economy, negotiate individually whatever you want, and we'll stick to that as the agreement. And that was the whole work choices, and then kicking the Howard government out because of work choices on steroids. But what the Liberal government brought in, I'm pretty sure, I could be wrong on this, but they brought in around 2016 an actual provision in the Fair Work Act that said you can't get, statutorily, you can't get compensation for the manner of the dismissal. And so Vision Australia were running this argument to say that, well, the manner of the dismissal being the fact that there was this investigation and it resulted in the termination of his employment. He can't get compensation for that because statutorily he's barred, despite the fact that, you know, they're past the deed issue by now. What Mr. Elisha was arguing though was it's not so much the manner of the dismissal, but we had a binding contract that said that in the process leading up to termination, you would follow the policy. The policy promised that you would do this. You failed in that promise, and you then terminated my employment in breach of those obligations. And the causation of your breach of contract resulted in me sustaining this psychological injury. And what the High Court effectively said in relation to that is that Addison Gramophone is one issue, and they recognise that since 1909 the workplace has changed and it can't be good law anymore. But it also recognised that there's this statutory provision, but that statutory provision doesn't necessarily stop a free binding contract where parties agree certain terms and conditions that they will do make certain promises and do certain things. And if they fail in those things, then compensation ought to be payable. The other interesting thing about Elisha is that in your employment contracts, it probably says that a policy is binding on the employee, but we'll use it as a guide as the employer, and we'll apply that policy whenever we think is appropriate to do so. So we're not, the terms of that policy are not incorporated into the contract, and we don't have to necessarily comply with those terms. The High Court said effectively what the lower court had said is, well, that's rubbish, because you can't have you can't have an expectation, or there can't be a term of the contract that necessarily has an expectation that an employee will do all of these things and the employer do. So that was the other. So what that means is, though, that your policies, you might not think that they're contractual terms, but they may very well be. So if you have a policy that talks about we must do these things in order to terminate your employment, if you don't follow that policy, you could end up in a situation like this Elisha and Vision Australia situation, where a breach triggers a psychological downfall that then follows in compensation. Anyway.
That's pretty much.
All right, it's 6:40 and everyone's getting tired. Any questions from anyone online? I think that's probably enough for tonight. I'm happy to come back if there are other questions that flow out of any of this. Is there any questions, Sharon, from anyone online?
No.
Okay, well, thank you everyone online for coming. Any questions here?
I was just going to say,
yes.
like we talk about the stress and stress. What if it's something in their outside life they're bringing that stress in, and their stress then affects the rest of the team?
That was what I was going to
The moment it's an employer's reach into a person's private life is limited. The moment that issue becomes a workplace problem, you've got a responsibility to manage it.
My
That's a
question,
performance issue then.
Well, it could be a performance issue, it could be a relationship issue, it could be a range of things.
Yeah.
So stay away from that.
for example, though, like,
So this is where I get onto Facebook, and I say, don't be friends with any of your staff on Facebook, because if you see people complaining on Facebook about stress and anxiety, that's potentially you're alerted to a psychosocial risk or hazard. So just be careful with that. Yes.
I guess I have.
So don't be offended if you start.
No, it's just that, you know, we've had a few things over the last year where different ones are going through court things with exes and all that.
Yes,
But it meant they've taken time off and
that because
you know,
yeah, that
coming in and not coping with their work because they've got all this going on.
you can't
You
ignore
know?
it
Yeah.
if it's affecting their work,
Yeah.
because it could be an explanation, but there's still things that you need to set in terms of expectations for them when they are at work. So you might be a little bit lenient based on
Yeah.
on those personal experiences, but that's not necessarily a complete excuse for doing nothing.
And I was more concerned, like, it
But the other
impacts
people, the
everyone
other
else.
people, the other
And they've
people.
got to carry the workload.
Yeah, and
That sort
you
of thing,
can,
yeah.
I mean, if people are complaining,
Yeah.
then there's no problem in my view of you saying to someone, listen, those personal matters are affecting the workplace. Can you please leave them at the door? I don't have a problem with that.
Is there a problem? I mean, the EAP, right? So a lot of us have EAPs.
Yep.
And
Um,
PHN,
Have that as well,
Have
which
that
is
for the rest of
fantastic.
you.
And I think in my mind, sometimes I think, oh, well, I've got that in place. That covers all this kind of stuff.
That's what, yes,
A little
that's,
bit,
yeah,
right? But it's clearly not.
not
But if
enough.
we as an employer or even a manager or whatever, there's no problem with us strongly, maybe strongly is not the right word, but recommending our employees to take up that, yeah. use it. Like,
I
is there-
actually
So,
did
yes,
Because
say
you
to the
do.
girl, if you need to, you know, that's there and it's free.
It's free, it's confidential, and I mean, we get a report back, I think, every month if anyone's accessed it. Obviously, it's confidential, we don't know who. But is there a problem, like, can that employee then take offence to us saying, obviously, like,
oh, I think it'd be a hard
hard push?
push to say we're offended by the fact that you referred me to a
Okay.
EAP.
Good.
What it's important about that though is that you can't outsource the solution. So the person might be stressed and you're saying go see EAP, but the expectation is that you're looking then at what if anything at work is causing that stress and
It's got to be
anxiety.
part of the solution.
That's right.
That's right,
Yeah.
yeah.
So
So it might be.
So it's not a-
right,
it's not a-
still not a situation that you can.
it's
you
not
know,
a
it's still
complete
work,
solution.
yeah, no,
Yes.
that's right.
Yeah.
But I think for a little while, it's probably been, oh yeah, we've ticked that box, we've got that covered.
Very
kind of
much so.
situation. Yeah.
And the same with and we haven't spoken about it tonight, is sexual harassment is a significant issue in the eyes of this particular government. And there's an expectation that you all have a sexual harassment prevention plan, which you
And
probably
Queensland put in their own rules
That-
last March, didn't
yes.
they? We had to write all that.
yes.
Yeah.
So and that's again
Legislation.
part of the tool when it comes to psychosocial hazards is that you ticked those boxes and you're constantly reviewing and updating them as you need to. The other thing that I found, I don't know if everyone remembered, but there was that moment in time where you had all those health promotions where everyone would have to record. You'd have teams at work and you'd all record how much you'd eaten or all the how many steps you'd taken.
We're still doing our steps.
Yeah. But all this information was being fed to the
Yeah, that's
employer
Yes.
about the teams and what they were doing. I was these days you kind of think,
No.
oh really? I don't really want to know. Because if you're not doing enough, is that causing an issue? Anyway, yeah.
It's a very interesting subject, but
It is.
it's scary, isn't it? And you always think, as you're saying things of, oh yeah, I remember that with her, or I remember that with him, or.
Yes. So, but as I said before, if there's one thing you take away, the code of practice.
Yeah.
Have a read.
The hard thing for me is there's 100 things in a day that happens
Yes.
that you don't actually physically say at 10:10 I've had this conversation with the staff member. It's just a bit of encouragement or a bit of brainstorming or a bit of this or a bit of that. It's not an incident, it's just day-to-day management, but over time it could be an incident and you wouldn't have written it down. Like,
That's right.
because I trust people.
Yes.
And I don't think that they're gonna be out to get me, but you never know what the future.
Yeah. I mean, I can't recommend enough that file notes are really important in every manager's.
A summary back to the employee to say, we've had a catch up today, these are the things
Oh, yeah,
that we take away.
absolutely.
That's
Perfect.
fine. That would count as a file note.
Yeah, that's the most contemporaneous.
Very good.
Yeah.
Because that's what I've done.
Because then if the employee writes back and doesn't say, I've got a problem with any of that, the expectation is that that's been accepted.
I was just thinking, when you said about AI, you do a file note and you say, we've had a meeting, these are the things we discussed, and then they put it through AI and they write this response with the long dashes and everything, and they go, yeah, okay.
Well, this is, so the Fair Work Commission at the moment has had like a 200% increase because AI is so affirming. Anyone that loses their job these days goes to AI and says, hey, I was sacked for this, is that unfair? And of course, AI says, well,
Yep,
yes, it's very unfair.
absolutely.
Yeah. Here's what you need to do. And so the commission's got this incredibly large
That is
number.
amazing,
Yeah.
actually. I can imagine that.
Yeah.
Because I read those emails.
So that's, they're constantly at the moment on a weekly basis changing their systems to try and deal with and then it might say, oh, but if you don't have an unfair dismissal claim, try a GP claim. So AI's,
Yeah.
Giving them the ideas.
Yeah. And this lady with anxiety, she says all the right things. Like in her responses, when I took to my HR people those responses, they
it's
say
AI v AI.
this sets her up for going into that other cycle.
Yeah.
So not the general provisions one.
General
So
protections, yeah.
and so I'm kind
Is
of
she
going.
casual?
She is, but even as a casual, because she's
General
anxiety, and I knew she had anxiety, and now she's stressed. Like it kind of just
Bless
This is, I guess, this is where
I
AI
think-
has its limitations
Yeah.
because
constructive
there are
dismissal.
ways that you can manage that.
Yeah,
But it's knowing and understanding the process.
Yeah.
And because you can always defeat
Yeah.
that AI process.
so I'm kind of going, you're free to have a job here. Unfortunately, I looked at the workplace accommodations. I can't help that, but I can make you ad hoc if that would suit you.
Yeah.
Like I'm not dismissing her. I'm not dismissing her, but I'm saying, if you can't work and the expected shifts, then we can make it ad hoc and then you may not get any. But you can still work here.
Yeah.
I thought either a really stupid question.
There's no such thing.
Or a really hard question.
But
And it's sort of not personal to me, but probably personal to everyone as like management. How do you not become the psychosocial hazard? And how do you not create that hazard? For example, what you were talking about before, where your staff is negative or anxious and then passing it on to your team.
Yes.
I sit with someone who's constantly negative and saying every second thing that comes out of their mouth is negative, and that negative energy weighs on you,
Yes.
and you feel like turning around and saying, shut up. How do you, other than HR and EAP, like obviously that's stuff you would reach out to, what protections can you protect yourself with to not fall victim to that person's issues? Does that make sense? I'm trying to word it.
Can I say what we did? We had someone like that, and I sat them all down in a room and I said, we're going to do above and below the line behaviors. If you work with someone, what would you like to see? And what takes away from your joy at work? And they said, if someone's miserable all day, every day, it's really hard for us to work with them. And so I wrote that up on a poster and gave it to all of them, and they signed for it. And I said, if you see anyone doing any of these things, you tell them, don't do that anymore. That's below the line. It makes me feel miserable. And so that for us worked, but it was,
we
I
have a
don't know.
behavioural charter,
How do you
and
call
you
that?
above the line, below the line, they
I-
sign when they
Above
start.
and below the line. And now when somebody new starts, I say it's really important that you fit into the team. This is our expectations around it. And there you go.
Yeah,
Perfect. That might help.
yeah, yeah.
Yeah.
It's just like, it doesn't put you and her against each other.
Yeah.
It's like
It's the
team
team together,
agreement. Yeah.
everyone agrees and everyone decided what.
Sorry, I interrupted.
No, that's right. That's a better answer than I was thinking. Well, this, I mean, that's it's very much the difference between, HR and looking at things purely from a legal perspective. We're always thinking what the obligations are from a legal perspective. HR, those practical solutions, they're really important. And so, if you can have access to HR professionals, then you might find solutions.
No, I use me.
The other thing about these kind of sessions is that there's
The knowledge.
the knowledge that's being
Yeah.
shared.
And the
That's
experience,
hugely valuable.
Yeah. Yeah. Good.
All right.
Yeah.
Thank you.
We'll end the meeting, so
Yes.
I can.
Thank you very much.
Thank you.
Online.
Oh,
Oh,
okay.
oh,
Yes.
comment on
Thank you.
Thank you, everybody. Thank you, Danny. Thank you.
No problem.
Thank you.
You have to do it.
I hope I didn't-